Thank you for joining us today for the Immigration Options After Graduation webinar. My name is Elizabeth Brooke. I'm an advisor here in Visa and Immigration. So while we're waiting for everybody to join, I'll just take a moment and share with you this calendar of events. We're hosting next week in honor of International Education Week. So on Tuesday night, we have an international trivia night with free pizza and prizes. On Wednesday, we have Passport to the World event from 1 o'clock to 2:30 during campus lifetime, and that's in the Melville Library, where you can come and get free international candy and popcorn. And then also on Thursday evening, we're having a global game night, and there's also going to be more food and prizes, free, of course, but you do have to register, please, for these events in SB Engaged. So now I'm going to take this down, and we're going to be hearing from our special guest speaker. Here we go. Brendan, you can go ahead and share your screen while I introduce you. Our special guest speaker today is Brendan Venter, who is joining us today to talk about the immigration options that may be available to you should you wish to stay and work in the United States after graduation. Mr. Venter is an experienced immigration attorney with the law firm of Harris Beach, with offices in Manhattan and Albany. Brendan and his team serve as Stony Brook University's external immigration counsel, and our office regularly seeks his expertise to help guide our office with respect to complex immigration issues. So Brendan will be talking to you today about employment-based visas and the immigration process. He's prepared an informative presentation, and after his talk, we'll have a brief Q&A session. If you have a question for Brendan, please submit it in the Q&A feature, not the chat. And try and keep your questions pretty general. Any case-specific questions should go to either your VIS advisor or your personal immigration attorney. And this workshop will be recorded and posted on our website for your reference. So without any further ado, Brendan, I'll hand it off to you.
Thank you, Beth, and thank you to the VIS office at Stony Brook for hosting me again. I've done this the last several years. Used to be in person. Used to be able to come down and see you all. And I remember last year doing this, I said, well, hopefully I'll see you all next year in person. So I'll repeat that, hopefully for real this time next year. I'll be able to actually come down and see you all again and do this on campus. But for now, we'll do it virtually. And like Beth said, we'll have time at the end for questions. So my goal today is sort of just to give you all an overview of what your options may be to remain in the United States after graduation. And obviously, I'm guessing many of you are here on an F1 student visa, which allows you to be here and to study. And in many cases gives you a little bit of work authorization after that, which we'll touch on a little bit. But what the focus of this presentation will be what happens after that. After I graduate, I'm no longer a student. How can I remain in the United States? What are the available paths for me to do that from a US immigration perspective? And so we'll go over some of the most common visa types, the most common options that we would see for an international student. So to begin, I usually go over these general concepts just to sort of orient you as to how our US immigration system works. And the way I usually view it is that there's three major categories that people fall into, which are listed here. Now, there are some exceptions to this. There are some people, for example, refugees or asylees may not fall necessarily into one of these specific categories, but the bulk of individuals here in the United States will follow one of these paths or fall into one of these main categories. So the first is what we call non-immigrant visas. That's what an F1 student visa is. A non-immigrant visa is any visa or visa status that is temporary in nature. So it's not permanent. It's usually a visa that's for a specific purpose. So it allows you to do certain things in the United States, but maybe not other things. And it's usually for a specific period of time as well. So again, it's not permanent. For example, an F1 student visa that visa or visa status is valid as long as you're enrolled in and attending school. But obviously, if you were to stop attending school, you'd no longer be maintaining your F1 non-immigrant visa status, just as one example. Sort of the next category or next step up from that would be, as compared to a non-immigrant visa, an immigrant visa or lawful permanent resident status. This is what many people know as a green card. This is a status that allows someone to stay in the United States permanently, and it's no longer tied to a specific activity in the United States. So once you're a permanent resident and you have a green card, you're no longer required to continue to go to school to maintain your status or maintain employment to maintain your status. You're allowed to lawfully reside in the United States permanently without an expiration date. And you basically can do essentially whatever you want in terms of permissible activities. Now from there, once someone has been a permanent resident for a certain number of years, in some cases, they may be eligible to apply to become a United States citizen through what we call the naturalization process. So if someone's been a permanent resident and been physically in the United States for a certain number of years, they can, if they want to, apply to naturalize to become a US citizen. That's not required. It's not mandatory. So there are people who remain a permanent resident for decades and decades, and that's totally fine as well. But US citizenship, it is different. Many people confuse the two and they think once I get a green card, I'm a US citizen, and they are distinct statuses. So they're not the same thing. Becoming a US citizen gives you a few more rights that you would not have as a permanent resident. For example, the right to vote. So US citizens can vote in United States elections, but permanent residents or green card holders cannot. The other main difference is your permanent resident status. If you were to, for example, leave the US for too long and not maintain a residence in the US, or if you were to commit a crime, you can lose permanent resident status or have that revoked, whereas US citizenship really can't be revoked or can't be lost once it's obtained. So this slide is what I call our alphabet soup slide, and it basically gives you a very high level overview of these three categories and sort of what some of the concepts are within those. In terms of non-immigrant visas, which is what we'll focus on at the beginning portion of this presentation, you can see there's many different categories and many different types, and these are not nearly all of them. I've put some of the more common ones here, but there is a visa category for just about every letter of our alphabet. They range from everything from visitors, either for business or tourists, which would be a B1 or a B2 visa, to someone who's invested in a business in the United States. That would be an E2 visa for an investor. Obviously, many of you are probably familiar with F1 visas for students, but these get pretty specific. So we have R1 visas, which are for religious workers. There are U visas, which are for victims of crimes who, if they cooperate with law enforcement, can get visa status through a U visa. So they get pretty specific in terms of what they cover. And essentially, when we look at non-immigrant visas, we're basically trying to match up what the person wants to do in the United States with one of these particular visa categories, to give them that authorization to enter the United States or to remain here and pursue that activity. Towards the end of the presentation, we will talk in this second column here about immigrant visas or the green card process. Within that category, you'll see the main distinction we have is there are family-based categories. So you can become eligible to apply for a green card or permanent resident status based on family. If you have a family member of a certain relationship who is a United States citizen or a permanent resident themselves. Or there are also employment-based categories or processes where an employer in the United States can sponsor you for a green card based on a job offer. So we will talk about some of those a bit later. And then obviously the last column, we have US citizenship, as we mentioned. So for the first few minutes here, I'm going to go through some of the more common non-immigrant visa types that you may encounter or you may be interested in pursuing. Like I said, I'm not going to go through everyone because some of them are a bit less relevant and less common, but we'll touch on the more common ones just to not make you an expert, but just to put the idea in your mind of what some of these categories are and what some of the options may be that you may be eligible for after you graduate. So the first one we're going to talk about, and it's first because it's usually the most common, the most typical visa category that we see in the employment-based context would be the H-1B visa. The H-1B category is for, it's a work visa, so it allows someone to be employed in the United States by a US employer in what we call a specialty occupation. And if you look at the law, there's a very complicated way they define specialty occupation, but essentially in the real world, what it means is a position that requires, as the normal entry-level requirement, a bachelor's degree or higher in a particular field or set of fields. So sort of a good example I use to describe this would be, I do a lot of H-1B visas for physicians and doctors. So obviously to work as a doctor in the United States, you can't have something less than a bachelor's degree. Obviously you need a medical degree or doctor of medicine degree. So because the normal entry-level requirement for a doctor is something higher than a bachelor's degree, that position usually will qualify as a specialty occupation and be a good candidate for an H-1B. If we compare that to, let's say, a nurse, which some nurses have bachelor's degrees, but many nurse positions for just an RN, a registered nurse, someone can become a nurse or start in that occupation with something less than a bachelor's degree. So you can become a nurse, getting nursing license in many states with just an associate's degree, a 2-year degree. So because of that, a nurse position likely would not qualify for an H-1B as a specialty occupation because the normal entry-level requirement is something less than a bachelor's degree. So that's really the threshold inquiry we're looking at. Whenever an employer says, hey, we have this candidate we want to hire, we say, okay, what is the position? Give us a job description because we want to look at that job and see, is this position one that as its normal requirement, does it require a bachelor's degree or higher? And usually employers will work with attorneys like myself in this process to do that evaluation and assess whether a particular position may work. There are, so in addition to the position actually requiring a certain level of education, it may seem obvious that the actual applicant, the person seeking the visa, must have that required education. So even if the position is one that normally requires a bachelor's degree, but the applicant may have a bachelor's degree in an unrelated field, or maybe they don't have their bachelor's degree yet, that probably wouldn't work for an H-1B. So it's matching up those two things. We've put some more information here about some of the details about the steps involved. I won't really go through those. That's getting a little bit into the weeds, but I put it there just for your reference. H-1Bs, in terms of a timeline, you can typically get approved for H-1B status for up to 3 years initially. And at the end of that 3-year period, typically you can extend for an additional 3 years. So the maximum period of time any individual can hold H-1B status is 6 years. So it's always good to plan ahead because what you don't want to do is say, all right, I've graduated, I've got a job offer, my employer can do an H-1B petition for me and I'm going to get my H-1B status and then I'm set. That may be true initially, but you want to keep in mind that 6-year maximum. You don't want to get to year 5 and say, okay, now my 6th year is approaching, what do I do next? Because typically in many cases, if your employment's working out and your employer likes you and wants to keep you and you want to stay there, a lot of times the H-1B will transition into a green card process to begin from there. So the earlier you can think about that and get that conversation going, the better, to make sure you're not running up on that 6-year limit of H-1B status and not be able to extend it further. So some other basics about the H-1B, we mentioned the specialty occupation issue. It does require an employer-employee relationship. So you can't do this as sort of a freelancer or what we call an independent contractor. It does require an employer to hire you, put you on payroll, pay you with what we call a W-2, make you an actual employee. It doesn't have to be full-time. It can be part-time employment, but it can't be as an independent contractor. It does have to be a W-2 employee. H-1Bs are employer specific. So what that means is if an employer files an H-1B petition for you and that gets approved and you obtain H-1B visa status, you can only work for the employer who has petitioned for you. It doesn't let you work for anyone you want in the United States. So sometimes what can happen if someone wants to work for more than one employer at the same time, they can have what's called concurrent employment or concurrent H-1B petitions, where each of those two employers would file its own H-1B petition for that same employee to authorize them to work for both entities at the same time. There are some complications when you work off-site sometimes. So if you're working at a location other than the employer's main location, that's also permissible. That's allowed. You do not have to work on-site at the employer, but there's some additional considerations there and things you'd need to document. But just confirming that arrangement is allowed. We talked about the 3-year initial period and the maximum of 6 years. So you might be thinking, okay, the H-1B sounds pretty straightforward. As long as I get my bachelor's degree and I find a position that requires at least a bachelor's degree, I should be all set. Well, the main caveat with H-1Bs and the main limitation to them is they're limited in number each year. So by law, the US government, our immigration system, only makes a total of 85,000 H-1B visas available per year. So 65,000 of those visas are for bachelor's degree holders. There's an additional 20,000 visas available above and beyond that for individuals specifically who have a master's degree or higher from a US college or university. So if you have a foreign master's degree, you'd still be within that initial allotment of 65,000. But if you have a US master's degree or higher, you can essentially be eligible for either one of these pools. So you get a little bit higher of a chance. Now, the way this works is there's only 85,000 total H-1B visas available. And there's way more people than that want H-1B visas. So how do they decide who gets them? Well, the way they decide is they conduct a random lottery. So every year, usually around March or April, the H-1B lottery season begins. And during that time, any employers who want to sponsor an employee for an H-1B visa have to submit an online request in this online lottery. So they submit a sort of simple registration form where they give basic information about the employer, about the employee, and they submit this all online to participate in the lottery. So usually that's towards the end of March, usually the last couple of weeks of March. Then in early April, US Immigration, so US Citizenship and Immigration Services, or USCIS, which is a government agency, they conduct this randomized lottery. And they'll take all of those online registrations that were submitted. From those, they will pull out or select the 85,000 total that can proceed to then file the actual H-1B visa petition or the H-1B application. So if you're not selected in that lottery, you can't even file the application for an H-1B. You're sort of out of luck and you're not selected in that year's lottery. If you are one of the lucky few who are selected, you file the H-1B visa petition, and it would then have a start date. The earliest start date it could have would be October 1st of that year. Because that's the first day of the government fiscal year when all the new visas become available. So a lot of times, what might happen is, especially for students, it can be difficult because you oftentimes may want to try to line up an employer before March of your final year, so that if you're someone who's going to need an H-1B, the employer can file a request or registration for you in that year's lottery. Because if you miss that March window, you can't file again until the following year. So if you're, let's say, graduating in May of 2022, ideally, you'd want to have employment lined up so that the employer could file a request for you in March of 2022 for the H-1B to begin October 1st of 2022. Now, if that didn't work out, there are other ways it can work. So let's say you graduate in May, you get your OPT, optional practical training, which is 1 year of work authorization that many F1 students can get after they graduate. So that will carry you over until the middle of 2023, let's say, once that's approved. So what you could do is your employer could then file for you next year in March of 2023. And if you're selected in the H-1B lottery and the employer files a petition for you, you can get what's called cap gap. This is getting kind of advanced, but you can get cap gap relief, which basically means your OPT, let's say if it expires in June of 2023, but an employer files an H-1B petition for you before that, your OPT automatically gets extended until October 1st, when your H-1B would begin. So it covers that gap in between when your OPT would expire and when your H-1B would begin. Just to give you a sense of the numbers, this past year, I think there were close to 300,000 or so requests submitted in the H-1B lottery for these 85,000 visas. So it's, about a 1 in 3, 1 in 4 chance maybe to actually get selected. So it's not ideal. It is a major limitation. There's been discussions and pressure to try to increase the number of H-1B visas for years and years, but it's remained at this 85,000 for quite some time. So it is what it is now. It's unfortunately sort of a numbers game, and a lot of it may be just out of your control. Now, one issue, we talked about the numerical limitation. One nice piece about this is that if you get a job at a college or a university, it does not necessarily have to be as a faculty member, but any position at a college or university where they will be your employer and they will be sponsoring you for your visa, colleges and universities are totally exempt from those numerical limitations I just talked about. So they can have as many H-1B visas as they want. They are not limited to those 85,000 that are available for everyone else. So if you do get a job at a college or university, you don't have to go through that lottery. You don't have to wait until that March filing window to submit the registration. Colleges and universities, because they're exempt, they can submit H-1B petitions at any time for a new or current employee. That exemption also applies not just to colleges and universities themselves, but also to some other entities. And the big categories there would be government research entities. So if some sort of agency that's a government research organization, they would be exempt, as would a nonprofit entity that has an affiliation with a college or university. So not all nonprofits are exempt, but if it's a nonprofit entity that has an affiliation with a college or university, that entity would be exempt from the H-1B limits. An example of that I see a lot would be hospitals. Many hospitals are nonprofit entities, and they'll have affiliations with a local college or university to place students at the hospital medical students or undergraduate students for some sort of clinical training program or internship or something like that. So if there is that sort of relationship, the nonprofit hospital, even though it's not a college university itself, it can be exempt from the H-1B limits. So because of those limitations on the H-1B and the sort of the numbers game that you have to play, a lot of times it can be helpful to explore what are some other available options aside if the H-1B doesn't work out. So we've listed them here. I will now go through some of these more common ones just to give you a flavor of what's out there. I mentioned a little bit about this work authorization for F1 students, or OPT, what we call. I won't go too far into this because your best friend for OPT issues will be your international student advisor at Stony Brook in the VIS office. They're the ones who will really walk you through how to apply for OPT, making sure you have everything in line for that. I know they have a bunch of workshops throughout the year to sort of go through that process with you. So take advantage of those opportunities and those resources that are available to you, because your international student advisor is a critical piece in you being eligible for OPT and making sure you get the application submitted during the right time when you have to. But very generally, if you're not familiar with OPT, it's 1 year of work authorization that F1 students are eligible for after they graduate. So usually within the few months before you graduate, you can submit an application for OPT, where once it's approved, you'll get an employment authorization card mailed to you that will allow you to actually work in the United States after you've graduated. But the position has to be related to your degree. So you can't use OPT to work in a position that's unrelated to the field in which you studied. Now, normally OPT is limited to 1 year. If you have earned a degree in a STEM field, science, technology, engineering, or mathematics, then you can potentially be eligible for an additional 2 years of OPT beyond that first year, so a total of 3 years. Your field has to be on this list that the US government puts out of qualifying STEM fields. So you'll want to cross-reference that. And you can only work on STEM OPT for an employer who is enrolled in what's called E-Verify, which is a federal government program that employers can use if they want to, but they're not required to. So not all employers use this. But E-Verify is a way for employers to electronically verify that someone they're hiring has proper work authorization in the US. So just keep in mind, if you're going to get STEM OPT, you can only work for an employer who uses E-Verify. Another visa we see sometimes, and some of you may actually be on a J1 visa right now, but what we call a J1. J1s are pretty broad, and they have a bunch of different subcategories. So there's J1s for students, for research scholars, for physicians. So anyone doing a medical residency in the US after med school would likely be on a J1. Some teachers, au pairs, and nannies. So they really cover a wide spectrum. But a J1, depending on what the opportunity is that you're pursuing, could potentially be an option. I won't go into some of these details, I'll skip that. But one issue I did want to mention with respect to J1s, just to keep in mind, is some J1 programs can subject you to what's called a 2-year home residence requirement. So for example, if you, for your J1 visa program, whatever it may be, if you receive funding from your home government or from the US government, for example, if you receive a Fulbright scholarship or a Fulbright grant to do research in the United States, whether it's from the US Department of State, the US Fulbright Commission, or your home country's Fulbright Commission, if you get funding from them, you will essentially certainly be subject to this home residence requirement. There are also some countries that have what's called a skills list, which is a list of categories or areas that they designate as high priority in their country. And so if you participate in a J1 program and you're from a country that has a skills list, you'll want to see which categories of program are on that skills list to determine if that will subject you to the 2-year home residence requirement. And what this requirement means is essentially when you finish with your J1 program, whatever that may be, you are ineligible to change basically to any other status in the United States or any of the most common statuses. You're ineligible for an H-1B visa, for example, and you're also ineligible for a green card or permanent resident status unless you do one of two things. One would be you return to your home country for 2 years. The other would be you get a waiver of that requirement. So you submit an application to say, here are the reasons why I should not have to go back to my home country for 2 years. You should allow me out of that requirement. I've listed here the 4 different ways you can get a waiver. And these are not all available in every situation. So this would be certainly a situation you'd want to discuss with a qualified immigration attorney to evaluate what your options might be for a waiver. But they range in complexity. The easiest would be what's called a no objection waiver, where your home country gives you a letter that says, we don't object. We are okay with this person remaining in the United States and not coming back for 2 years. But they get more complicated through what's called a hardship waiver. If you have a US citizen spouse or child who you can show would suffer exceptional hardship if you had to go back to your home country for 2 years, or a persecution waiver if you can show that you would be persecuted based on your race or your religion if you were to go back to your home country for 2 years. So those are some potential paths or eligibilities for a waiver of that requirement. But the J1 visas and waivers are quite complicated. So if you do end up on a J1, I would say it's certainly something you'd want to discuss with an attorney. Another option that's substantively very similar to the H-1B is what's called a TN. So if you happen to be a Canadian or Mexican citizen, you potentially may qualify for a TN visa. It's only available to Canadians and Mexicans. So if you're not one of those, a citizen of one of those countries, you can't pursue a TN. But TN is for a specific list of occupations that are listed in the NAFTA treaty, now the USMCA treaty, between the United States, Canada, and Mexico. So most of the typical professions are on that list: teachers and professors, many scientists and engineers, some medical professionals, accountants, attorneys. So if you're going to work in one of those occupations and you have the required education for that occupation, then the TN may be an option for you. It's attractive because there's no limits on numbers like there are with an H-1B. So oftentimes if I encounter a Canadian or Mexican, we'll explore the TN to see if that may be an option. There are other visa categories that, again, are similar to the H-1B that are based on treaties the US has with specific countries. So like the TN for Canada and Mexico, there's what's called an H-1B1 for Chilean and Singaporean citizens, or an E3 visa for Australian citizens. Again, substantively, these are very similar to the H-1B in that they require the position to be one that requires at least a bachelor's degree in a specific field or that specialty occupation. Now, outside of the free trade visas or the treaty-based visas, there's another visa type called an O1, which, depending on your background, may or may not be an option. The O1 is for individuals who have extraordinary ability in their field. So it's really may not be available to someone who has just graduated, unless maybe you've gotten your PhD and during your PhD program, you've done a lot of research or other academic activities in your field. But the O1 requires you to show essentially an extraordinary level of achievement, that you've made contributions to your field that have been recognized through awards or through materials that have been published or written about you, that you've published articles yourself that have been cited by other people in your field and relied upon by other people. So it's really showing that you've made significant contributions to your field. I've listed here some of the categories or criteria that are set forth in the law that are things the government looks at to evaluate whether someone may qualify. But O1s can be quite flexible because they're not limited to a specific occupation or specific industry. So they're available to people who work in science, education, business, athletics, the arts, performing arts. So O1s, if you are someone who's really done something significant in your field, the O1 could be an option to explore as well. Now, for those of you who may be entrepreneurial and interested in maybe starting a business or buying a business in the US to run here, you may think about or consider what's called an E2 visa, which is for an investor. So if you are from a country with which the United States has a treaty of trade and commerce, which is many, many different countries. Notable exceptions to that are India and China. So US currently does not have such treaties with those countries. So E2 visas are not available to Indian or Chinese citizens. But if you are a citizen of a country that has one of these such treaties, and like I said, you are interested in purchasing a business or starting up a business in the United States, and investing an amount of money to do that, you can potentially qualify for an E2 visa based on your investment. And what the E2 visa does is it gives you authorization to be in the United States to manage that business, to direct your investment. So that can be a nice visa for people who fall into that situation. So to transition a little bit here, I want to now start talking about some of the permanent options in the United States. So up till now, we've talked about non-immigrant visas or the temporary visa options, which again are limited to specific activities in the United States. The green card options would be, like I said, once you become a permanent resident and get a green card, there's really no more limitations on what you can and can't do in terms of work in the United States. So many people who are on non-immigrant visas will at some point want to transition to an immigrant visa or a green card. So this is sort of just another overview slide to give you a sense of how does the green card process work. Unfortunately, in most categories, you can't just submit an application for a green card right away. It requires a process that has many different steps. So most employment-based green card processes, where you have an employer who says, we want to sponsor this person for permanent resident status based on a job offer. Most of those processes are a three-stage or three-step process. And we'll talk about each of these stages a little bit, but you can kind of get a sense here of how long the process is. I usually estimate for a typical employment-based process to budget about 2 years from start to finish. That process can be much longer depending on where the employee is from. And specifically, if the employee, the individual, is from India or China, the process can be significantly longer. We'll talk about why that is. But this will give you sort of a sense of what the different stages or steps are in a typical green card process. So one thing to keep in mind with green cards is sort of similar to what we talked about with the H-1Bs. Green cards are limited in number each year. So there's only a certain number available worldwide each government fiscal year. It's not an unlimited supply. And in many of the categories we have, all of the green cards are used up every year. There's higher demand than there is the number of green cards available. And so there's complicated factors and formulas that go into play as to how many are actually available and to individuals from which countries. But for your purposes, suffice it to say that there are limitations that in many categories get reached every year. So what happens is, instead of conducting a random lottery like they do with the H-1B visas. For green cards, they allow everyone who's interested to proceed with the process and get their paperwork in. But if there's not a green card immediately available, they put you in line. So you are subject to these quotas. You're put in a backlog where you are essentially waiting to have a green card become available to you. And this is all determined by the date that you actually started the process. So they put people in line based on the date they filed the first paperwork towards a green card, and then they work through that backlog as the years progress. Now, an important document to refer to look at, well, what do these backlogs look like right now, is what's called the Visa Bulletin. And the Visa Bulletin is a document that is published every month by the US Department of State. And what it shows is what the current cutoff date is for a green card being available to individuals of certain nationalities and in certain categories of either family-based or employment-based green cards. So I'll show you what the Visa Bulletin looks like. This is not the whole thing. I've pulled one of the charts out of the Visa Bulletin for this current month, for November. And what this essentially shows to me, as someone who understands how to interpret this, this tells me, gives me a snapshot of, for the current month, for November 2021, what do the current backlogs look like? Where do things stand right now? So you'll see in the left-hand column, we have the different categories of employment-based green cards, all the way from EB1 to EB5. EB1 means the employment-based first preference category, and there's certain requirements for that category. EB2 is employment-based second, and so on. We'll talk about in a later slide what those mean, but for now, those are just the different categories. Along the top, you'll see different countries or different areas of the world. So the first column, we have worldwide, which basically means every country that's not specifically listed in a column to the right. So China, El Salvador, India, Mexico, the Philippines, they have their own columns just because they have, in many cases, a greater number of people applying than the other countries of the world. And those countries are the ones that sometimes hit their limit per year. So if we look, for example, at the EB2 category worldwide, so we go down to EB2, scroll over to worldwide, we see the letter C in there, which means current. What that means is that category, there is no backlog. So for EB2 worldwide, that category is not utilized its full number of green cards that are available each year. So that's good. That's what we like to see. But if you go over to the next column, EB2 for China, we see a date in that box of November 15th of 2018. Now, what that means is if someone from China, who was born in China, is pursuing an employment-based green card in the EB2 category, the current cutoff date, as of today, as of November 2021, the cutoff is November 15th, 2018, which means, as of today, a green card is only available to people in that category from China who started the green card process before November 15th of 2018. So if someone started the process November 16th of 2018, they are not, as of today, they don't have a green card available to them. They're still waiting in that backlog. So they will have to continue to wait until their date of filing, or the date they started the process, which we call a priority date. They'll have to wait until their priority date falls within the cutoff. Once it does, then they will be eligible to actually finish the green card process, submit their final application to have the green card issued to them. So if you think about what that means, as of today, green cards are available to people who started before November 15th, 2018. So people in that category have been waiting about 3 years in that backlog to finish the process. If we go over to India, it's a little bit more extreme. That cutoff date is December 1st of 2011. So someone from India could have started the green card process in sometime in 2012 in that category. So they've been waiting 9 years and still would not have a green card available to them today. So it's quite a difference depending on where you were born. It is dependent on a country of birth, which I'll mention. So sometimes I encounter clients who were born in India, but later became a Canadian citizen. That unfortunately would not allow you to fall into the worldwide category because they look at country of birth. So you would still be subject to the backlogs for India. So obviously a huge problem with this is there are people who are waiting years and years to actually finish the green card process. They have an employer who started it for them. They're still employed in the United States, but it takes almost a decade or more to actually finish the process. Now, in that time, just going through the green card process and having that started, that by itself does not allow you typically to remain in the United States. So at the same time as an Indian national is waiting in this 10-year backlog, they also have to continually maintain a valid non-immigrant or temporary status, such as H-1B. So this would be one of the exceptions to that 6-year limit on H-1Bs that I mentioned. If you are someone who's stuck in one of these backlogs and you've had a green card process started for you, but you're just waiting for your time in line to come up, if you're in that situation and you're in H-1B status, your employer can continue to extend your H-1B past that normal 6-year limit. So that's one thing, one at least benefit that they give to people who are impacted by this. So if we go back, I'll go back a couple slides just to this again, and we say, okay, here's the green card process. Basically the 3 main stages of the employment-based process are this PERM labor certification, the visa petition, and then the adjustment of status application to become a permanent resident. So we'll talk about this labor certification first and what that involves. And without going into too much detail, essentially what you need to know here is that in most employment-based green card categories or processes, for a US employer to sponsor a foreign worker for a green card or for permanent resident status, what the employer first has to do is show that they have made efforts to fill that position with a US worker. And the way they do that is through what we call a test of the labor market. That's what this whole PERM labor certification process is. It is the employer going through certain steps to show that they have made an effort to fill the position or identify if there are any qualified US workers out there. And only if the employer does that and gets through the process without a qualified US worker applying, can the employer then sponsor a foreign worker for a green card based on employment. So the employer has to recruit and advertise for a position as if they have an opening. Even if you're currently in that position, let's say an H-1B status, the employer has to advertise and recruit as if they have an opening. And they have to see if anyone applies who meets whatever the minimum requirements are for that position. And if they get someone who applies in response to that recruitment, who meets the minimum education and experience requirements, and that person is a US citizen or green card holder, then technically the employer cannot proceed to sponsoring a foreign worker. So that's the primary requirement here, is the employer has to show there's a position that they cannot fill with a US worker. Once they do that, once the employer does that required recruitment, if no qualified US worker applies, the employer can submit the actual application for labor certification, where they're essentially getting permission from the US Department of Labor to say, okay, you've done the proper steps, you've made a good faith effort to try to identify if there are qualified workers in the United States, and no qualified workers have applied, so you now have permission to sponsor a foreign worker for permanent resident status based on that job opportunity. Once the PERM labor certification is done and approved, then the employer moves on to what's called the immigrant visa petition, where the employer files a petition with US Immigration to say, okay, we've gotten permission from the US Department of Labor. Here now is our petition for this foreign worker, and this foreign worker meets our minimum requirements. This person has the required education and experience, and we want to therefore sponsor them for a green card based on employment. The final step is the adjustment of status application, where the foreign worker can actually submit their application to adjust their status from a non-immigrant, whatever your status may be, to an immigrant or a permanent resident. So it's that final step, the adjustment of status, that's dependent on a green card being available. So if you're from China or India, there may be a delay in between the immigrant visa petition and the adjustment of status application while you wait through those backlogs. Now, there are some green card categories that are exempt from the labor certification requirement. So for these categories, the US employer does not need to go through those recruitment or advertising steps. They don't need to test the labor market and see if there are minimally qualified US workers. The government has pulled these categories out and said for these types of workers, we'll allow you to sponsor them even if there are minimally qualified US workers. We don't want that to be an obstacle for these people. So I'll talk about some of these categories specifically very briefly. The first is an individual of extraordinary ability. It's very similar in many ways to the O1 non-immigrant visa we talked about, in that it requires you to show that the employee or the beneficiary has extraordinary ability in his or her field. This is really, it's a demanding category. It's really for people who have risen to the very top of their field in the sciences, arts, education, business, or athletics. So it really requires you to heavily document what your accomplishments are and show that you've received a high level of national and international recognition for the things that you've done in your field. One nice thing about this category, and another that I'll talk about later, is you can actually file it as a self-petition. So even though it's in the employment-based categories, you can file this on your own, even if you don't have a US employer who's willing to sponsor you, or even if you don't have an actual job offer. As long as you can document sort of what you'll be doing in the US, if you'll be self-employed or working for multiple employers, you actually can file this petition without a concrete job offer or a US employer to file for you. So it can give some people an opportunity where they may not have that actual job offer from a US employer. These are the different categories of evidence that they will look at when evaluating this. So the categories are here. I won't run through them each, but what you have to show is that you have evidence at minimum of at least 3 of these categories. If you do that, if you meet that threshold requirement of satisfying at least 3 categories, then what the government will do is they'll look at all of your evidence as a whole. So just meeting 3 of these or more by itself does not mean your case will get approved. That gets you to the next step, which is then they'll look at everything and say, okay, holistically, based on the totality of all the evidence, is this someone who has risen to the top of their field? And it's a more subjective inquiry, subjective analysis. So really, for these petitions, you have to heavily document them. You have to be very persuasive and convincing as to why you are at the top of your field. A similar category, but it's a little bit more narrow, would be for outstanding professors or researchers. So like the extraordinary ability, this is also EB1, employment-based first preference category, but this is specifically for generally college and university faculty. It can be used for research positions that are not at a college or university, but the bulk of these that we see are for college and university faculty. And it's the same type of framework. There's these 6 categories. You have to show you meet at least 2. And then once you do that, they'll look at your case as a whole to see, are you someone who's really outstanding? Another category, which is in the EB2 category. So it's a little bit of a step below in terms of how demanding it is, how much evidence they require. So it's called a national interest waiver. This is another category where you can self-petition, so you can file this on your own behalf. It's another category where you do not have to go through the labor certification. But this requires you to show that you have exceptional ability in your field, which is a little bit lower than extraordinary. But you also have to show that you will be working in a field in the United States that is of significant national interest or national importance. So you're doing some sort of research that relates to public health or the environment or the economy, or something that you're doing is of national importance or substantial importance to the United States as a whole. So you do have to make that additional argument or that additional connection for this type of petition. Now, I'll briefly mention outside of employment-based, there are some options that don't rely on, your accomplishments in your field, don't depend on you having a job offer or a US employer to file for you. And we mentioned earlier, there are family-based categories, family-based processes. So if you have a relative who's a United States citizen or permanent resident, that relative may actually be able to sponsor you or file a petition for you to get a green card based on that relationship. So only certain relationships qualify. You can't have an aunt or uncle petition for you. You can't have a niece or nephew or a grandparent. Those relationships don't work. They don't qualify. But if you have a spouse who is a US citizen or green card holder, or if your parent is a US citizen or permanent resident, depending on your age, or you have a brother or sister who's a US citizen, you may be able to qualify for permanent resident status through that relationship. Now, the waiting periods are different in these, just like they are for employment-based. So you have to consult the visa bulletin to see what's the current backlog for these. Spouses of US citizens are what we call immediate relatives. So there's no backlog for those. There's no limit on the number of visas. So if you were to marry a United States citizen, your spouse could sponsor you or petition for you in that category for you to become a permanent resident. But if we go the other end of the spectrum, a brother or sister of a US citizen. So if you have a brother or you have a sister that's a United States citizen, they can start the process for you. But the backlog in that category worldwide right now is in excess of 10 years. In some countries, it's closer to 15 years. So it's not an immediate solution, but it is a process that's out there and available. Another one I'll mention briefly just to wrap up is what's called the diversity visa lottery. And this is to go back to our theme of lotteries, we talked about a little bit. It's another process sort of like the H-1Bs, but this is in the green card context, where if you are from a country that does not traditionally send a high volume or a high number of people to the United States each year, you can submit an entry in the diversity visa lottery each year to try to get a green card that way. And it's basically just a set of 55,000 immigrant visas or green cards that they distribute randomly each year. The name diversity lottery is consistent with what the purpose of this program is to try to encourage diversity in the United States, to distribute some of these green cards to people from countries that wouldn't otherwise typically send many people to the US. So, for example, India, China, some of Europe would not qualify for this. So you can check it. It changes sometimes depending on numbers, but you can find the list at any time online of which countries would not qualify for the diversity visa lottery. But if you're not a citizen of one of those prohibited countries, and you have at least a high school education or 2 years of work experience, then you can participate in this. There's no cost to do so. It's a very easy form you submit online. So there's really no downside to doing this if it's something you're interested in. Unfortunately for this year, the entry period just ended yesterday. So if you're interested in this, you'll want to wait until next year, but it's usually around October so that they open it up. So just keep that in mind if this is something you want to pursue. The odds are not great. I was looking this morning at the numbers just to try to get some context. So in the last 3 years, so which would be 2018, 2019, and 2020, the number of people that have submitted entries was 23 million, 22 million, and 11 million in the most recent year for 55,000 visas. So the numbers are not very good. But again, there's no downside. There's no cost to doing it. It doesn't restrict you from pursuing any other visa options at the same time. So just something to keep in mind that you can participate in every year if you want to. I won't go into some of the specifics on that just for the purpose of time. So we're right at about an hour right now. So I'll end my portion of the presentation. I've listed here some resources that can be useful to you. Some government websites and other organizations you can check for resources. Obviously, as I mentioned, anything relating to your F1 or OPT, the ISSS office or the BIS office will be your best friend on that. I would, consult them with issues there. And beyond that, obviously, as I mentioned throughout the presentation, immigration law is very complicated. It's one of the more complex areas of law we have. And I too often see people who try to do some things themselves and end up getting into trouble or missing opportunities. And so whether it's me or some other immigration attorney, I think it's always good before you proceed down a path to speak with someone who works in this area, just to make sure, you're thinking about all the things you need to think about. You're not missing anything that could end up backfiring and get you into trouble later on. So my contact information is here. I'm happy to have any of you contact me if you'd like. If you have questions about your situation, I'm certainly happy to speak with you. But for the remaining time we have, I'm happy to answer any questions that may have come in.
All right, thank you so much, Brendan. My name is Margaret Hartoflis. I am the International Student and Scholar Assistant in Visa and Immigration Services. We have some general questions that we've selected for Brendan to answer. So the first question we have is, what is the regulation for non-full-time employment under H-1B? Is there a minimum amount of hours per week or month?
So there's no minimum. It can be a couple hours a week, as long as there is a legitimate bona fide job opportunity where you'll have that employer-employee relationship with the U.S. employer. It does not have to be full-time. It can be part-time. Is certainly okay. And like I said, remote work is also okay on an H-1B. A lot of times we get questions about that. So remote work, part-time work is okay on an H-1B.
Great, thank you. Next question we have, can a student go from F1 status to H-1B status directly without passing through OPT?
So theoretically, that's possible if let's say you were on an F1 and you are going to be graduating in May and you had a job offer from a cap exempt entity, so a college or university was going to hire you, they could theoretically file an H-1B petition for you to change your status to H-1B immediately when you graduate. So there'd be a seamless transition and no intervening period in between your graduation and when you would start on the H-1B. So that's possible. But more often we see people who do apply for OPT, and that would be required for the cap subject employers. Because as I mentioned, the start date for those H-1B petitions cannot be earlier than October 1st. So if you're going to be graduating, let's say sometime in May, you usually need something to carry you over in between that and the October 1st start date of the H-1B. But if it is that sort of situation where you have the exempt employer who has a job offer for you and they want you to start immediately, that could work without having the need to apply for OPT.
Great. Next, we have a student asking if it's very strict that a graduate must find a job that matches their major, or if it doesn't match, would there be a hindrance on their H-1B application?
Yeah, so that is sort of a gray area because the government isn't necessarily, there's nothing you submit. When you apply for OPT, there's not necessarily anything you submit that gives a lot of detailed information about what job you're going to have. So there isn't necessarily immediate oversight on that, but that rule is always in the background. And so if you were to, let's say, file for OPT and use that to work in a position that was not related to your degree, where that could come up is if you then file a later application to change to H-1B status, you're going to have to submit in that petition documentation of how you've been maintaining your status. And so where you've been employed since the time that you graduated and got OPT. And so if the USCIS officer reviewing the H-1B petition sees that you've been working in a job that's not related at all to what your degree is, they could challenge that. They could issue a challenge and say, well, you haven't really been maintaining your status because the position you've been in during your OPT is not actually sufficiently related to your degree. So there's no bright line rule on that. It's a case-by-case analysis to determine if it's sufficiently related. But generally speaking, the closer relation there can be, the less risk there's going to be of there being any sort of challenge like that.
Okay, thank you. Next, we have, can H-1B be extended beyond 6 years if you started the green card process?
Yes, so if you are, there's basically two ways to do that. If you've started a green card process at least a year before the end of your 6th year, so basically before the end of your 5th year, if an employer has filed that PERM labor certification, then you can get additional H-1B extensions beyond in 1 year increments beyond the 6th year while you go through the green card process. The other alternative is if you are from a backlogged country, which is typically India or China, and you have gotten as far along as you can in the green card process, meaning you've done the PERM labor certification and or you have an approved I-140 immigrant visa petition, but you're waiting in that backlog, then once you reach that point, you can get 3-year H-1B extensions. So extensions for 3 years at a time up until you're able to finish the green card process and work through that backlog. So there are a couple limited ways in which you can sometimes get extensions beyond the 6th year, depending on where you are in the green card process.
All right, another question we have is, there are fewer than 20,000 spots for graduate students with US equivalent degrees for the H-1B lottery. Does this mean the demand for these visas is less? And does this also mean that there is a higher likelihood of getting this visa?
So to clarify that, so there's 85,000 total visas. 20,000 of those H-1Bs are set aside for people who have at least a master's degree or higher from a US college or university. So how it works is every year in the lottery, everyone submits a registration who wants to participate. What the government will do first is allocate those 20,000 for master's holders of master's degrees or higher. So if you have a US master's degree or higher, you'll be in that initial lottery for the 20,000. If you are not selected among those 20,000, you go back into the main pool for the other 65,000. So it works out that you sort of get 2 chances at it if you have a US master's degree or higher. So having that degree does increase your chances quite a bit because you can potentially get one of those 20,000. And if not, you go back into the main lottery for the other 65,000.
All right, thank you. Next question we have is, what is the maximum number of times your employer can apply for the H-1B lottery?
There's no maximum. So I've had a couple clients who have done it 3 or 4 years in a row, just because they've been able to sort of piece together their status or even do it while they're abroad. But there's no, they can only do it once per year. So in each year, you know, in this year, your employer can't submit 20 registrations for you for the same person. They can submit 1 per employee, but there's no limit on the number of successive years they can do that. So, you know, a somewhat common situation we see would be someone who gets OPT for the first year and has an employer file for them that year. If it's not successful, if that individual is eligible for the STEM extension, they get 2 more years of OPT. So they'll get continue working for the employer. And then in the next year, the employer will try again in the H-1B lottery. If that doesn't work out, the person still has another year left of OPT, and the employer will try again in a third year. So it's not a one-time thing. The employer can try as many different years as they want.
Thank you, Brendan. We have another question regarding the O-1 visa. Does it apply only to your specific fields, or can it be in a non-related field?
So the O-1, you have to show you have extraordinary ability in a particular field. So the accomplishments and achievements that you have would have to be in a particular field that you would identify in that O-1 petition. So it doesn't, I'm not sure I understand the question, but it doesn't necessarily have to be related to your education, if that's the question. If, let's say, you got a degree in a certain field, but then after that you became super famous in some other field, you could do an O-1 based on your accomplishments in the other field. That's not the degree, the field in which you did your education. But you would have to show that you have extraordinary ability in a specific field or area that you would identify in the petition.
All right. Next question we have is, can green holders eventually get citizenship?
Yes, so
Green card
that would be,
holders.
yep, that would be the final step sort of in the immigration journey is once you become, if you do get a green card and you become a permanent resident, I mentioned you can stay a permanent resident forever. So I've had clients who have been a permanent resident for 20 or 30 years. You would have the option, however, of applying to naturalize to become a US citizen if you want to. Now, the earliest you can do that typically is 5 years after you have become a permanent resident, after you have gotten your green card. So that clock starts the day that your green card is issued. So any time you spend in the US before that doesn't really matter. The clock starts when you get your green card, and we go out 5 years, and that would be the earliest you would become eligible to become a US citizen. There is one exception to that, which would be if you are the spouse of a United States citizen. So if you're married to a US citizen, even if that's not how you got your green card, but if you're married to a US citizen and living with that United States citizen, you can become eligible to apply for naturalization 3 years after you get your green card. So the period's a little bit shorter for spouses of US citizens, but everyone else, it's that 5-year period.
So we have 2 more specific questions that we have selected left. So first we have is, I have a master's degree in the United States. Currently, I'm pursuing my PhD, and have a job offer for next year. I plan to graduate mid or end of next year. Can my employer apply for the H-1B lottery even if I haven't graduated yet?
Yes. So depending on what the position is and what the requirements are, they could apply for you just based on the fact that you have your master's degree. If it's a position that requires a PhD, there would be a little bit more thought and analysis that has to go into that. But generally speaking, yes, they could submit an entry for you in the lottery. And then what you'd want to do is probably wait until you actually have the degree to submit the petition itself. So you'd probably wait till after the graduation if a PhD is required. But if it's a position that requires a master's degree, or that you could perform with just a master's degree, then the fact that you're still pursuing a PhD would not prohibit the employer from pursuing the H-1B for you before you graduate.
All right, thank you. Last question. If I have held a previous J1 and have obtained a waiver and are now on an F1, am I eligible for a J1 again after graduation? And can I apply for a J1 for a waiver again?
So yeah, it depends. That would be an issue you'd want to talk through with an attorney probably, but generally speaking, once you've gotten a waiver, then you're not limited on the types of statuses you can get. So if you were on a J1, got a waiver, then you could obtain F1 status. As to whether you could go back to J1, probably, but it depends on the specific category of J1 visa that you held and will hold, because some of the J1 categories have restrictions on how long you can have those, and restrictions on going back to a J1 after you've finished. So that just depends on some of the specific facts. But if you were to, let's say that were permissible, you were to reacquire J1 status for a different program, and that program subjects you to the home residence requirement again independently, then you would again need another waiver, because you can, once you get a waiver, you can resubject yourself to the J1 home residence requirement. So if after you get a waiver, you re-enter the US on a J1, or you obtain J1 status where that home residence requirement is attached, you can become re-subject to that home residence requirement and need a second waiver, basically.
Great. Thanks so much, Brendan, for answering our questions. This concludes our Q&A portion of the presentation. For those who have additional questions, please contact your international advisor or an immigration attorney.
Thanks again, everybody. Take care. Bye, Brendan.
Thank you.
Thank you. Bye.